Okay, well, welcome to the understanding of SB 354, expanding relative placement. Under SB 354, a training to train family members and reentry legal aid advocates webinar. Next slide. Let me explain a few logistics and how to access written material you can find in the chat, as well as how to use the Q&A function at the bottom of your screen. We will answer all questions at the end. Next. All written materials will include citations plus a link for the MCLE form to get credit for your continuing learning in the chat as well. We know how important continuing learning is for legal and lawyer advocates. I would like to introduce myself. My name is Bobby Butts. I'll be the moderator for this evening. I am the assistant director of the Free Project, which is a program within Starting Over Inc. based in Riverside, California. On the panel, I want to introduce Kimberly Dunn, a policy fellow from A New Way of Life, Sabrina Forte, a lawyer from the Alliance for Children's Rights, Meredith Wallace, a lawyer from the East Bay Family Defenders, and Tyler Sutherland, a lawyer from the Legal Aid Foundation of Los Angeles. Please see the chat box to have access to everyone's bio to get to know them more. These are some really wonderful people. I enjoy working with them and understanding and learning more things to continue helping the families I serve. I would like to talk about the overview of the program and why relative placement matters. Core changes of SB 354 and how to take advantage of SB 354 and the other benefits of SB 354, and then we'll do questions and answers. We are not providing legal advice today or details in the Indian or tribal rights or parents' rights. We're going to do a quick poll. Rita, can you put the poll up real quick? So tell us about yourself. That's the poll. And then we'll give it like about 1 minute to answer. And then I will go ahead and introduce our first panelists. Awesome, awesome, awesome. Thank you for joining us today. Thank you for telling us about yourself. I would like to turn it over to Kimberly Dunn.
Thank you, Bobby, so much. Read the next slide, please.
Yeah.
Hello, everyone. My name is Kimberly Dunn, and I am a All of Us and None Fellow here at A New Way of Life, Reentry Project, and the mother of two beautiful children, Ira and Anijah. My life has been a challenge and a cycle of trauma. I have suffered from domestic violence, substance misuse, homelessness, anxiety, and separation from my children, which ultimately led me into incarceration. I do not make any excuses for my mistakes. Since I've been home, I went straight to a program by request to the court. I completed this program. I have been able to advocate for parents and formerly incarcerated women and men just like me to be in a positive, productive way for positive change. I am also a client assistant at night at a mental health facility, and I have the privilege of going to school part time for social theory at Los Angeles Trade Tech College. While struggling, my kids were taken from me. They were adopted, and now I have no rights to see them, visit them, or have any contact with them. Their bond is non existing. If SB 354 was implemented while I was going through this hard time and I was able to have my family, my children with my family, today that bond would be existent. I would be able to be a part of my children's life. They would be able to see me transform today and the social justice movement I'm a part of. It's very important with SB 354 being implemented that families, they seek family members to raise their children and that we advocate for that. And the reason for that is because my children have not seen my transformation. I have made a social biography to reach out to the adoptive parents to be a part of my children's lives. I have not received any contact back. It's a very trying time in my life, but every day I look forward to positive changes. And today, SB 354 being implemented is a positive change for parents that are going through it now and future parents that will be going through this. Today, my kids and I have hope that one day we'll be reunited, but today, other parents, just like me, have a choice to have their families with their kids with their families. And thank you so much for allowing me to share today.
Thank you so much, Kimberly. Sabrina?
Thank you, Kimberly. I think that it's hard to follow Kimberly's story and how powerfully she communicated it. And just want to add what many of us here, certainly all of us colleagues here presenting today, know to be true and is illustrated in Kimberly's story, which is that connecting a child with a family member is associated with better outcomes for that child, increasing overall child well-being. Children who are placed with a relative are more likely to have better educational outcomes, fewer manifestations of trauma. They're more likely to remain with their siblings. And importantly, to Kimberly's point, it preserves the child's connection to their family, their community, and their culture, which has tangible and intangible effects. And in your written materials today is a synopsis of the different research studies and reports that talk about these positive outcomes associated with children living with their relatives. Next slide, please. The next couple of slides just kind of put into numbers a couple of the areas where placement with relatives has particularly significant benefits. The first represented in this chart is when young people are placed in foster care in sibling groups. And overwhelmingly, relatives are more likely to support sibling groups as those sibling groups get bigger. We can see that the proportion of relatives accepting large sibling groups, 4, 5, or 6 siblings at a time, is significantly higher than individuals who are not known to the children prior to placement, or certainly congregate care placements. And the next slide shows the stability that relative caregivers can provide for older foster youth, young people ages 14 to 17, who are often claimed to be very hard to place, but when they are placed with the relative in the first instance, they're more likely to be in that relative's home after 12 months, whereas if they are placed in group care in the first instance, they're much more likely to change placements and bounce around over the course of that year. And we know that that placement stability has significant effects on the outcomes of those young people, especially at that transition age as they're preparing for adulthood. So with that kind of research-based grounding, I'll turn it back to our moderator, Bobby.
Thank you, Sabrina, for that. That was really intriguing to know. And those are just some things that, you know, we need to keep near and dear to our heart when we're dealing with Child Protective Service, child welfare, especially when trying to get our loved ones out of the system and back into us. Thank you so much. So I would like to say Governor Newsom signed our bill into law October 8th. A special thanks to our co-author Nancy Skinner, Assembly Reyes, and Assembly Bryan, and our co-sponsors Legal Services with Prisoners and Children, A New Way of Life, Alliance for Children's Rights, Children's Law of California, the County Welfare Directors Association of California, Underground Scholars, University of Riverside, and Starting Over Inc. Next slide. We feel very proud of SB 354. It allows county welfare agencies, CPS, and juvenile probation departments to grant criminal exemptions for child-specific resource family approval for relatives to take in a child, get placement, even if the relative or someone else in the relative home has a conviction that was previously non-acceptable. The court can order placement even if the agency hasn't granted an exemption of RFA approval yet. State funding is available for these relative homes. Hold on.
So to explain how this core chain works in practice, we're going to talk about relatives, sibling groups, and NRFM preferences, and I'll get to NRFMs in a minute, the different types of placement at different stages in a case, and what you need to obtain each type of placement, and how SB 354 changed these requirements. Next slide. So to start off, I will talk about what is a relative. A relative is in dependency a broadly defined term, and it's defined as any adult related to the child by blood, adoption, or affinity within the 5th degree of kinship. And I'll show you what 5th degree means, but to start off, that includes step parents and step siblings. It includes your great and your great-great grandparents or relatives, and it includes the spouse of all of these persons, even if the marriage was terminated by death or by divorce. Next slide. So this is a really helpful infographic to show you if the person is within the 5th degree of relatedness to you. And so you look at the dependent child, which is down in the bottom left, and everyone that is circled is within that 5th degree of relativity. So all of these people are considered legal relatives and receive the relative preferences in the law that we will get to shortly. And so this is not something that you need to memorize, and we should be sharing these slides with you after this presentation so that you will have a copy of this infographic, because I can never remember if great grand aunts and uncles count or not, but with this slide, it makes it very easy to check and see. And so what you can also see is that most, a lot of relatives are encompassed in the 5th degrees of relativity. So when you're looking for people who are subject to relative placement, there are a lot of extended family that are that count as relatives. Next slide. So next, we'll talk about what the relative preference is. The relative preference is a preference in the law which requires the Child Welfare Agency to actively look for possible relative placements early in the case and at every stage thereafter. So once identified, the relative home must be the first placement to be considered and investigated before looking to other types of placement. And the court has a duty to make sure that the agency did the search for relatives early in the case and then at every stage in the case thereafter. Next slide. So the second preference we're going to talk about today is a sibling group preference. So to start off, who is a sibling? This one's not as complicated as who is a relative. A person related to the identified child by blood, adoption, or affinity through a common legal or biological parent. So as this clearly encompasses step siblings, full siblings, half siblings, or all siblings under the definition. Next slide. And the sibling preference is that when siblings have been removed from their home, either as a group or individually on separate occurrences, the siblings must be placed in foster care together unless it has been determined that placement together is contrary to the safety or well-being of any siblings. So there's two things to parse out here. One, it is sometimes a challenge when siblings are living in separate households and then they are separately removed to make sure that the sibling preference is being followed. It is more straightforward when the siblings are removed at the same time from the same household. So that's something to look out for when you're coming across a family to see if the sibling preference has been followed. And again, just like the relative preference, the dependency court has a duty, a legal duty, to make sure that this rule has been followed. And so if it turns out there are multiple siblings, 2 siblings in one household and another sibling, a third sibling in a different household, the court has a duty to ensure that they are placed together unless the placement is contrary to the safety or well-being of any sibling. And so that's another really important point to note. And this sibling placement rule favors placement with relatives because relatives, like Sabrina mentioned, are more likely to take a whole sibling group. Next slide. So the third preference beyond the relative preference and the sibling preference is the NRFM preference. So what is a NRFM? It's part of our alphabet soup that exists in the child welfare space, and it stands for non-related extended family member. And so we use the handy dandy acronym NRFM to describe who this is. And a NRFM is an adult caregiver who has an established familial relationship with a relative of the child, or has a familiar or mentoring relationship with the child. So to point this out, to break it down a little bit more, this could be a relationship with the parent, right? So mom's best friend is likely a NRFM due to her relationship with the parent, or it could be child's godmother who has a specific relationship with the child and maybe not related to the child, but the tie to the child makes them a NRFM. So giving some examples here, this includes relatives are NRFMs because they have that relationship, but relatives also are relatives and have a relative placement. But if you have a relative who's outside of the 5th degrees that I showed on that previous chart, then those relatives who are 6th degree, 7th degree relatedness get similar preference to NRFMs, because even though they are technically relatives, they are not the legal term of art relatives, so they qualify as NRFMs. And so teachers, medical professionals, clergy, neighbors, family friends, you regularly see, that's my godmommy. That's like who the NRFM is. That's a really common way to identify them. And in the next slide, I will get to some of these questions about how NRFMs are included in SB 354. So there is a soft preference implied in the law, preferring relatives, preferring NRFMs to strangers. So there's a hierarchy in the preference where for possible placements, parents are the #1 possible placement. And then relatives are the 2nd possible placement. And then NRFMs are an additional possible placement with preference over a stranger, congregate care, etc. And so this NRFM preference is, like we said, a soft preference, and some of the special rights that apply to relatives also apply to NRFMs, and some of the special changes that happened as part of SB 354 apply to NRFMs, and we will get to that shortly. And so the NRFM rights under SB 354. So the highlights. NRFMs cannot get placement or RFA approval if someone in the home has a non-acceptable conviction. That remains the same. That the preference that changed for relatives about folks with non-exemptable convictions did not change for NRFMs. However, here's the upside, is NRFMs can get assistance in qualifying for emergency placement and can get assistance in child-specific RFA approval. So that is really important because that's a really big change for NRFMs. And so we're going to dive into what emergency placement and child-specific RFA are shortly, but to flag now, that is the big change that from SB 354 that applies to NRFMs, is the emergency placement and child-specific RFA component. And I think I turn this over back to Meredith now.
Thank you. Hi, everybody. I just wanted to explain that there are more technical advice. This is going to be a repetition for dependency attorneys, but for families, we wanted to make sure people understood some of the more general stages of dependency. So there are 4 main stages of a case that matter for relative preference. The first is when a child is initially removed by the police or a social worker, and this happens before there's actually a court hearing. The second stage is the grouping of 3 initial hearings: the detention hearing, where the court considers whether to detain the child from the parents; the jurisdiction hearing, which is usually combined with disposition, which is whether or not the court actually has the power to detain the child more permanently; and then the disposition, what's going to be done now that the child is detained. So those take place over about a month in the beginning of a case. Then if the child remains detained, you move to the reunification period, where parents are offered reunification services. Those last about 6 to 18 months, and in an extraordinary circumstances, 24 months. And then finally, if parents are unsuccessful reunifying during that time, you have a termination of reunification services hearing, and that's followed by the post-reunification period. That's when you have permanency planning hearings, and if you're having an adoption or a legal guardianship, a 366.26 hearing. So in these 4 stages, what's really important to remember is that the relative preference weakens at the stages. So for part 1, you have a very strong preference. And if there is a relative available at initial removal, the county shall place with the relative and has to do the assessment, which we're going to talk about right away. And then you move to the next one, you have a really strong preference still, but not quite as strong in the 30 days of those initial hearings. Then during the reunification period, you still have a strong preference, but it's very unlikely that you would get emergency placement. And finally, in post-reunification, you have a much, much, much weaker preference. So keep that in mind while we talk about the rest of the slides. Next slide, thank you. The emergency placement requirements, and we were talking about those in the initial removal and in the initial hearings. You can get emergency placement in that first month, essentially, and then after that, you can get either full RFA approval, which can take months. Sometimes it has a very long list of requirements, which you can look at in the written attached materials, or you can get a compelling reasons placement, which is essentially a temporary placement for a compelling reason, which we will go into. During the reunification period, you can only get an emergency placement, which is the quickest way to place a child, if the child has to change placements from wherever they're located. So if a child, one way to remember it is if a child goes to the assessment center because of a 14-day notice or some other emergency, then you can reassert your right to get the very quickest method, which is emergency placement. And compelling reasons can be pretty quick too. I've seen it in about 2 weeks. So it's definitely way quicker than RFA approval, but again, you can see how the law favors trying to get this relative placement early and makes it easiest in the early stages. Next slide. Thank you. The emergency placement requirements, and again, these are not only the fastest way, but the easiest requirements. The county would do a CLET scan, which is a limited criminal background check. You don't actually have to have your fingerprints approved to get the placement. They'll ask you to do fingerprints, but the CLETS is essentially just a database search. Then they search the Child Abuse Central Index, which the short acronym is CACI. For if you have a flag on the Child Abuse Central Index, it could be because you had an investigation of your home previously for child abuse or neglect, or because you had an actual case yourselves. If you get flagged on the CACI, it doesn't necessarily mean that you can't have placement. So just keep in mind that if you know you might be flagged on CACI, to be able to come forward to the social worker to explain what was going on, have any paperwork with you about what went on with the investigation, if it was closed, why it was closed, et cetera. So that's not a deal breaker. CLETS itself originally was a deal breaker, which we will get back to if you had a hit on CLETS. The next is a home safety inspection. That's much more limited than a full RFA. They're just coming in to look for obvious safety risks to the child. And the next is that you have to show that you're able to care for the child. And that's more of an interview format plus questions about your financial status. So being able to care for the child also includes your ability to protect the child, likely from the parent who you are related to, or are a NERFM for. So you have to be able to say that you'll follow the court's orders, et cetera. And also, if the only issue for your ability to care for the child is funding, the social services through SB 354 has to help you, which we'll get more into. Next slide. So the changes to the emergency placement and compelling reasons for the purposes of relatives are going to be very similar, except the amount of time. The relatives can get an emergency placement even if someone in the home has a previously non-exemptable conviction, if the court finds that there's no health or safety risk. So if you have a hit on, what that means is if you have a hit on CLETS, they tell you it's non-exemptable, you could still come and petition the court and petition the other lawyers to support you in having the placement. There's also emergency caregiver funding available for these homes if funding is a barrier, and also for after the child is placed. You can get funding quicker than, if you are familiar with the past, sometimes emergency caregivers will be waiting a long time to get any funding, which could cause some pretty big problems. The agency also has to help you as a relative or a NERFM seek resources if that's the only barrier to placement. Next slide, please. Thank you. Compelling reasons that this is the change from emergency placement to pay attention to. You have to have the full home assessment that would have been required by the RFA. So it's not just the quick come look through for obvious safety hazards, but you also have to have a compelling reason for the child to be placed with you. But that's very loosely, it's left open to a lot of discretion. So usually, it's usually because you had a hit on CLETS and now the agency still wants to place with you. So this is, it's very wide and there's a lot of discretion. I wouldn't be too worried about either that or the full RFA home assessment. Next slide. So the changes to compelling reason, again, it's similar to the emergency. You can still be granted for someone with a previously non-exemptable conviction for relatives. And again, the caregiver funding is available. Next slide. So the full RFA approval requirements, I told you that they include a long laundry list of things that you can look at in the materials to review. But the other changes under SB 354 that we wanted to cover is that the agency can grant a child-specific RFA approval to a relative home. Again, even if there was a conviction that was previously non-exemptable. So just to explain full RFA, with an emergency placement or a compelling reason, that you still have to get a full RFA approval. These two things, emergency placement or compelling reasons, are considered pending RFA approval. So if you get over a hurdle where the judge says like, oh, well, this is safe, I'm okay with this conviction, you're still going through this long RFA process. So it's important under the law that you still, under SB 354, can get the full approval with a non-exemptable conviction. But just keep in mind that it's not over at that point for relatives and parents who are listening. Oh, thank you. RFA is resource family approval, which I think I forgot to say, but I see it's in the chat. Okay, next slide. And then the agency has to consider child-specific RFA approval. Again, this is if you've already gotten placed and you're looking for child-specific approval. If the child is already placed with you, and if you have an established and significant relationship with the child. Keep in mind, if you are, as I think Tyler was saying, if your mom's best friend and the child that is removed as a baby, your emergency placement is the established and significant relationship. So the fact that it's a very young child isn't going to be a bar. And then the relative who's granted exemption and child-specific RFA approval, again, will be eligible for state funding and at federal levels. So that's good. Next slide. I think this is back to Bobby.
Oh, what a plethora of information, Tyler and Meredith. You guys really brought it home for the legal advocates as well as for the families too. I appreciate you guys being so detailed about what needs to take place when trying to make sure. So now let's get into how to get placement under SB 354. For family members, use the guide to SB 354, which is in the written material to back up your request, excuse me, to back up your request for placement. Give it to the social worker or the court when you ask for placement. If you are attorney, if you find an attorney to help you, give them the attorney the guide too as well. There is an easy way for you to accurately access your legal rights without having completely understand the part of the new law. Also, there's detailed guide on how to get placement under SB 354 in the written materials. We are adding the link to the document in the chat now. Thank you, Rita, for adding the links. Rita's been adding all the links, so thank you. Next slide. Act quickly. Assert your rights, make a paper trail, make a written record. The best written records are emails, text, letters, or Zoom recording transcripts with permission to record. That shows exactly what is said on each side. Otherwise, make written notes of each communication, including face-to-face conversations, court hearings, like what you said, what they said, always date and time of the communication. Act quickly. Requirements for earlier placements are easy to meet. Preferences weaken at each stage of each case. Don't be disencouraged. Be persistent, stay consistent. Remember, create a paper trail. Next slide.
Sorry.
Know the key players in the juvenile dependency court. Social workers are the ones that you will interact with the most, with the parents, caretakers. They're employed by the county welfare agencies and may be called the Child Protective Services or the Child Family Services, or may have another name. You can ask to speak to the social worker supervisor if you're having trouble with the social worker or not hearing back from them. County counsel, attorneys for the social worker and the child welfare agency. You'll see this person in court. Your attorney will communicate with this person. The juvenile court judge, what makes the most important decisions in the case, but agency makes some decisions on its own. Criminal exemptions, RFA, and adoption assessments. SB 354 allows courts to order emergency placements with relatives over agency objections. Parents and parents' attorney, with their support, the kids would have an easier way to reunify with family members. The child and the child's attorney, minors counsel. Older children have the right to express their wishes directly to the court. And social worker. Attorneys tend to speak for younger children. There's more on that on the guide to SB 354. And then the current caretaker of the child will be reporting to the social worker on how the child is doing. Usually not represented by any attorney, usually not in court, but sometimes. Court appointed special advocates, volunteers who spend time with the child and reports to the court on the child's well-being and best interests. De facto parents, if a current or former caretaker has a childlike bond with the child, they can ask for a de facto parent status, which allows them to formally participate in certain hearings with attorneys. So we'll move over to getting legal assistance.
I think that's me, Bobby.
Yes.
So it says not essential at the top of this slide. What's important to remember is I would consider these in order of the necessary need for escalation. So when you're initially seeking placement as a relative, the best resources are the social worker and then the attorneys for the minor and the parents. And of course, I would say the first step would be your ability to communicate with the parents in order to get access to the parents' attorneys, I think is also an important part. What you want to do is get their support in speaking to the judge, being considered by placement by the agency. If you aren't getting any traction, I think the next step would be to seek help from a legal aid organization. And again, as Bobby was pointing out, having a record of how you've contacted people and it hasn't worked is really important to be providing to anyone you are contacting in legal aid to say, look, I had these issues or I'm trying to get placement. This includes, and I believe this will be talked about later, if you end up getting denied for placement and you want to appeal that decision. And then, you know, the last step is that obviously there are a lot of nonprofits involved here who are really supportive of family placement and can help you be a resource or a referral to another organization for help for legal assistance if necessary. Next, thank you. The main steps practically, the first thing is to tell the social worker that you want immediate placement. It's important to know where the child is, just to keep in mind that there's different jurisdictions. There's a flyer with full steps in the written material that's available. The second is to come to court and to tell the court that you want immediate placement. This is it. In the beginning, we were talking about the sort of checks and balances and making sure that family placement actually goes through. So the social worker has a duty to investigate you, to find you as a relative and to assess you. But the check and balance on that is that the court has a job to make sure the social worker is actually doing that. And under SB 354, the court has a role that's even greater in that the court can evaluate, despite the agency's recommendation, whether an emergency placement with you or a compelling reasons placement makes sense. So keep in mind that the court is a really important player. That so much of dependency happens outside of court that sometimes people forget that the judge is actually the person making all the decisions, not the social worker. So that's step 2. Step 3, if you have gone past the first 30 days, there's already been a disposition hearing and you're in reunification, you're going to want to consider filing a JV 180 form. A JV 180 form is the form that goes along with the Welfare and Institutions Code 388 motion, which we will talk about a little bit later. The reason to do this would be, one, to flag yourself as a relative if the first 2 steps have not yielded an actual investigation. And just keep in mind that this is an enormous bureaucracy and you're not always going to get attention right away, even though the law is saying you need it. So there are different ways to flag, and a JV 180 is one as well. The next part is that if you're filling out, actually for anything, JV 180 or to talk to the social worker, the court, and other lawyers, make sure you have all of the information that supports your placement request. This includes all of the information about your relationship to your child, the relationship to whichever parent you're a relative or a NERFM with, and just information about yourself, your community, anything you think that would be supportive of why the child will be happy and safe with you. And then the last part is that you can appeal a denial of placement or appeal a denial of an RFA. Thank you. And the next part, this was more on finding the social worker. Obviously, we said you have to contact the social worker, but you do have to find them sometimes. They are technically required from the very beginning to be looking for you constantly. But that's not what we hear in practice. We hear relatives say a lot, you know, I was right there, I'm in the child's phone, like, why wasn't I contacted? So keep in mind that you're going to need to be proactive. You can also give the social worker a guide to SB 354, especially get ahead of, look through the written materials, see if you think you have a conviction that might flag something, and then know that you need to get ahead of it, right? So giving them, they might not be familiar with changes in the law because they are very new. So making sure that you have those written materials. And then, as Bobby said, and we really can't say it enough, the 2 things I would say you can't say enough are create a paper trail, just to make sure that you always have a record. And the second is to be doing this early and often, right? So don't get discouraged, but also remember that in the timeline, your relative preference is waning. So it's really important to go as quickly and as strong as possible in the beginning of, well, also, sorry, I should mention children. It's also really traumatic for children to be in foster care. So it's really, I'm sure that you, for family that are watching this, I'm sure you don't actually need to be encouraged to try to find the children and get them to the actual home they recognize, but it is really important to not get discouraged. Next slide. Again, we talked about ways to tell the court you want immediate placement. There is a JV285 relative information form that you can look up, and you can always Google the JV forms if you get confused or can't find your written materials. But the 285 form essentially has, it helps you list all of the things the court is going to be really interested in. So it's like a cheat sheet for preparing yourself to be asking for placement. You also should find out when and where the court hearings are. You can look up online where the court is for the county where they're removed. Some counties like Alameda are still doing virtual appearances. So it's important to figure out whether or not if you show up at the court, there will actually be court. And you can always do that by calling ahead and just asking what the procedure is in that jurisdiction. And the next is that you attend the hearings. You can, when you have a hearing, they call for a specific case. And if anybody has questions about online versus not online, we can talk about it. But essentially, because everything is confidential in dependency, you can only be present for the case that is about the child you're related to. So you would ask to speak at that point. You can also tell the lawyers on the case, like, I'd like to speak to the judge about placement. You can ask the minor's attorney or the parent's attorney that's friendliness to your case to say that to the judge, or you yourself can raise your hand and ask to speak when appropriate. That's the key phrase for judges, is to say when appropriate. So they don't think you're trying to speak out of turn. That can make people pretty cranky. The other thing would be to bring a written letter to the court if you weren't given a chance to speak. And okay, next slide, I think is Kimberly.
So when you want to talk to a social worker, you always want to encourage to talk to a social worker. You always want to be at your best. You always want to keep it appropriate. You never want to get angry with your social worker. You always want to be very communicative and also document it. The key thing today is to always document everything that you do with the social worker and the judge and keep a report. And the reason why is because the best way how to build a relationship with the judge is first dress to impress. You always want to dress to impress. You want to be no makeup, little to none makeup, always be in a business attire, and you always want to have what you call documents that state, you talking to the social worker from what time and what time. That's how you'll build a relationship with the judge. That is the best way to build a relationship with the judge. Don't talk out of turn. Always communicate with your lawyer. Have communication with your lawyer. And know that if your lawyer is not helping you or advocating for you the way you feel, always request to the courts that you want a new attorney. It is possible. You have to probably request 3 or 4 times with my experience, but I do know that that is possible. So just key things. Keep documentation that will always have a good rapport with the judge, and dress to impress. And always be positive when you talk to the social worker, and keep it very minimal, but always document everything. Thank you.
Thank you, Kim, for that great advice. That was wonderful. I want to turn it over to Meredith so she could talk about gathering information to support the request for placement.
We did talk earlier about a JV 180, and just because that's a pretty foreign concept, wanted to make sure that there was a full slide about a 388 petition. In a 388 petition, you are saying that an order needs to be changed. The order is the judge ordering placement with someone else. And you're going to say, if you're filing a 388 petition because you were previously denied placement, but you believe that you would be under SB 354 able to have the kids in your care, that would be the change in circumstance. A 388 petition needs either new evidence or a change in circumstance. And then the new order you want is immediate placement with you. And you always have to say why that's in the best interest of the child. And again, if you look at that caregiver information form that I mentioned before, it will help walk you through the steps of what the court is actually looking for. Next slide. Oh, there's more information, by the way, in the written information about how to fill that out. Sorry. Okay, now next slide.
Thanks, Meredith. So, types of documentation to gather. As Kimberly said, spoke earlier in the presentation webinar about a social biography that she had created. So, as the Assistant Director of the Family Unification, Equity, and Empowerment Project, we have a thing called Free Hubs, which is participatory defense, focused specifically on child dependency court processes. The Free Hub supports families facing dependency court, the child welfare system, or child protective service to better navigate and understand what to expect and avoid certain pitfalls related to their desired family outcome. It enables people with criminal convictions or without criminal convictions reunification opportunities. Furthermore, dependency matters include foster youth, but also their family and its circumstances. Is the child welfare system denying you or someone you know child placement because of criminal convictions? We want to hear from you. Come join a community of leaders and parent experts. In this space, we will help you complete a social biography and avoid certain pitfalls and just be prepared so you can stay up to par, so you can stay in the race to get your loved one or your children back into your family. Free acts for volunteers to support Free Hub parents, partnerships with other community-based organizations to help set up new Free Hubs in their communities so we can start to heal and lift up some of the guilt and shame that is associated with being a part of the Child Protective System, CPS, or any process. Next slide. So, like I said, I'm the Assistant Director of the Family Unification, Equity, and Empowerment Project. And we have one-on-ones with parents, former foster youth. We educate communities to the historical and current aspects of the child welfare system. We challenge and change the dominant narrative as it relates to formerly incarcerated people and their ability to love and care for their children by lifting their stories and their narratives, getting policies and practices changed to reflect the value of our children. That's where we were able to get this law together through meeting at the community. So SB 354 has always been something we've been working on since 2019. And just to see it be a law, it is so exciting. We sincerely appreciate the work that we can do together in this through our lived experience. We come together and build community with directly impacted people, creating strategic communication plans, public education awareness, and actions that will change the narratives and policies that impact us. Free acts for volunteers to assist in outreach, sharing of stories that will shape the new narrative, and a child-centered approach to this work. What does the child want or need, and how can we minimize their traumas? I'll turn it over to Tyler.
Thank you. So now we're going to talk about how to appeal. So I want to make one distinction at the very beginning of this slide. The process to appeal a denial of placement is not the same as the process to appeal your RFA approval. And so appealing a placement, at the end of the day, the placement is what takes place in dependency court. And so the displacement, the process to contest that is, like we've talked about throughout this, working with the attorneys in dependency court, working with the social worker, and taking those steps. But separate and apart from that, you can be denied RFA approval. And those things often go hand in hand. The reason you might be denied placement is because you were denied RFA approval. But there is a separate process to appealing RFA approval, and that is what is talked about here on this slide. So to start off, you are entitled to written notice of your denial of RFA, which includes the date of the denial and the reason for the denial. And you should contact the child welfare agency if you have not received this written notice. And this written notice is called a notice of action. And on the notice of action, it should tell you, like it says, the date of the denial, the reason for the denial, and also explain how do you appeal. And how you appeal an RFA is by completing a form that's on the second page of the RFA notice of action, which asks for just basic information, your name, your contact information, the reason that you disagree with the agency's decision, and whether or not you have an attorney or an authorized representative. And in these RFA cases, you can be assisted and represented by an attorney or a non-attorney. So if you know of someone who's gone through this before, there are peer type navigators that exist out there, or if you just need help because you need special help in these circumstances, you can get someone to help in addition to just representing yourself. Now, you submit your notice of action by sending it back to the agency that issued it. And the address and all the contact information is in the notice of action as you receive it. And you have 90 days from the date on the notice of action to file this appeal. I'm gonna just say here, RFA appeals are very complicated, and we don't have a ton of time in this presentation to do a deep dive into this process. But flagging here the timelines, and I will discuss the process a little bit further here. So when you are denied RFA, depending on the reason for the denial, it might go to one of two different administrative bodies to adjudicate it. So one option is that it goes to the Office of Administrative Hearings, OAH, and this is for what typically are categorized as more serious reasons for denial. But often relative caregivers, their cases go to the California Department of Social Services State Fair Hearings Division. So when you send in your notice of action, the first thing that comes back to you is an acknowledgement that your request for hearing has been received, and that acknowledgement will direct you to which administrative body is going to be in charge of your case. So at that very first step, you'll find out if you're an OAH or you're with State Hearings Division. Now, the procedures differ a little bit depending on which route you go, which is why we don't have a ton of time to go into this in a lot of detail. But in both cases, you have the right to get the county's documents that they are using against you in the case before your hearing so that you can review all the documents. You have a right to present your own evidence, which can include documentary evidence, which is what Bobby's been telling you to do all along. Keep your documents, because when it comes time for the hearing, you submit your documents to the other side and to the judge. And you also have the opportunity to present witnesses. So you can have witnesses who are lay people, who are your friends and family, who can support your case. If the case is based on a criminal records exemption, evidence about your transformation, what was happening back then in your life when you were convicted, and what's happening now is usually taken well. You can have letters of support or testimony from the boss at your job who knows that you're doing a good job at work, your clergy, or someone related to your religious institutions. And also therapists, anyone that you think really shows that you are, would be a safe placement for the child is usually good evidence. And you will also have the opportunity at the hearing to cross-examine the witnesses that the county puts on against you. This is a little bit complicated, but you can ask them questions to try to poke holes in their arguments and assumptions that they've made about you. And one thing to flag is to check to make sure that they've done all of the procedures required by SB 354. because as we know how counties move, they sometimes don't, they're not as up to date. And so they might have, it's possible they use the old rules against you when they decided your case, and making sure that they used the current standards, that they considered a child-specific approval would be something I would inquire about during the hearing. Lastly, in addition to presenting evidence, the judge in both cases might ask you additional questions or ask you for additional documents to provide at hearing or after, and you get a written decision in each case. So eventually, you know, your answer comes in the mail after a little bit of time. So that is the nuts and bolts of what the hearing process looks like for RFA denials. And no matter which hearing venue you go to, if you lose, you can challenge that decision in court. If the hearing is with CDSS, you actually have 2 ways to appeal. The first one is called a request for reconsideration, which is due within 30 days of receiving your decision. And then the other one is a writ of mandate. If your case goes to OAH, you can do a writ of mandate, which is a lawsuit to seek an overturn of the previous decision based on the judge's abuse of discretion. Writs are a little bit complicated. It's, again, I would seek the assistance of a legal service agency if that is available to you for assistance if you want to challenge the appeal in court, but it is absolutely something that you can do. And that is the nuts and bolts of RFA appeals. And so I will pass it back to Sabrina.
Thank you, Tyler. Thank you, Tyler, for that wonderful information and that breakdown. It was much needed to hear that. I liked how you simplified it so we could clearly understand what we need to do next. And so I want to talk to you about the other benefits of SB 354, and I'm allow Sabrina to take it away.
Thanks, Bobby. We spent most of today talking about the core change of SB 354, which is principally allowing relatives seeking child-specific approval to receive child-specific approval, even if they have what was previously a non-exemptable conviction, or a conviction that would be non-exemptable for someone who wasn't a relative seeking child-specific approval. I'm just going to give a quick overview of some of the other provisions of SB 354 so that you have them in the back of your minds in case they're relevant to your or your client's advocacy. One thing to know is that SB 354 does apply to juvenile delinquency proceedings when a child has been ordered into the care, custody, and control of the Juvenile Probation Department, also known as a placement order or a suitable placement order. Welfare and Institutions Code 727.05 allows for the probation department to place the young person with a relative or NERFM on an emergency basis when resource family approval is pending. And SB 354 updated that law and expanded it to say that the juvenile court could order that emergency placement even if an exemption or RFA is still pending. And then a caregiver who's requesting RFA in order to care for a young person who is on a placement order under probation supervision is eligible for the same protections through the RFA, the approval process, including appeals that we talked about today for families caring for kids in the child welfare system. And again, that's only if the young person in the juvenile justice system is on a placement order, has been ordered to suitable placement, not everybody in the juvenile justice system. This was addressed briefly in the Q&As, but the simplified exemption process, which was available well before SB 354 and allows the child welfare agency to provide an exemption for a resource family applicant based on their fingerprints and their RFA background check forms. if those misdemeanors or felonies don't require a standard conviction and occurred in the past 5 years for misdemeanors or the past 7 years for felonies, those timelines have shrunk a bit. So now the simplified exemption process now applies to misdemeanors over 3 years old and felonies over 5 years old. No criminal exemptions are needed for any infractions. There was a small cleanup in the law explaining that, you know, infractions don't require the entire criminal exemption process. So those are some additional benefits that may come up in your advocacy, and happy to answer more detailed questions about any of those. But with that, I'll turn it back to Bobby.
Thank you, Sabrina, about the other benefits and reminding us of the laws that were already existing to help bring family reunification. So I know with SB 354 being into law, those should be able to help the other laws to be of use in a better way. So thank you for that information, Sabrina. So during this time, next slide.
This is the slide.
Okay. Okay. So during this time, we'll do the question and answer. Please fill out the evaluation form. We'll put the link in the chat right now. And I will look at the questions and see what we have inside the Q&A. So there was a question in there. It says, what prior convictions are safe under the new law? Does it depend on how long ago it happened, the type of conviction? So there was 2 answers. Sabrina, would you like to talk about it again?
Sure. There are, you know, different rules that apply for relatives seeking child-specific approval, and then everybody else. For relatives seeking child-specific approval, the majority of convictions are eligible for an exemption now, even if they were previously non-exemptable. The law does make an exclusion for certain serious and violent felonies that occurred recently. Those are not eligible for an exemption, even if it's a relative who's seeking child-specific approval on the basis of their relationship with the child. It was just determined that that subset of convictions, crimes against children, et cetera, would just not be considered for an exemption, but most others are. And I also included in the Q&A a link to the background assessment guide, which I think is helpful for assessing which convictions are eligible for all applicants who are seeking a standard exemption or a simplified exemption or an exemption for something that occurred within the last 10 years or the last 5 years. The background assessment guide is a document that's created by the California Department of Social Services as part of its resource family approval implementation. And they've updated, it's called the BAG, Background Assessment Guide, to reflect all the changes in SB 354 and have really thorough lists of exact, like, you know, down to the penal code citation, what convictions are eligible for exemption and which ones are not. So I would suggest consulting the BAG with any, you know, if you have questions about a particular conviction. But for the core change of SB 354 for relatives seeking child-specific approval, it's a little more simple because it's most convictions except for the most serious.
Thank you, Sabrina, for that in-depth answer. I see also Meredith Wallace, she had put on there simplified exemptions. Time was shortened, no misdemeanor within the last 3 years, previously 5, no felonies within the last 5 years, previously 7. And so I'm gonna go to the chat box and see some questions. I think I see. So from Karen says, how can advocates support and encourage relatives to be honest if they've had criminal history? For reasons we may all understand, relatives lie, but it makes it hard to build trust. Kimberly Dunn, I think you could answer that one.
Yes, I can. Can you repeat the last part of the question, Bobby?
Okay, so the last part of the question says, for reasons we may all understand, relatives lie, but it makes it hard to build trust. So how can advocates support and encourage relatives to be honest if they've had criminal history?
So it is really honest. If when I was going through my situation, I didn't say that I had a criminal history, and so being honest to tell them that you have criminal history will help you out. You just it's the way that it's again about how you communicate. So when you are honest about your criminal history and you're putting it down, you have to. It's the way you communicate. You have to show a good character and know that you're not the person that you were before.
Thank you, Kim. Anybody else want to add to that?
Yeah, so I just want to add a little bit. I think Kimberly's totally right from the perspective of the relative. And so just adding as the perspective of the advocate in this situation, I think also it's clear communication because you're going to get as a fairy threshold, you're going to get a khaki and a cleanse. They're going to know. So there's no hiding it. And so making sure that you say like, be really honest up front about this because you're going to find out, and then it's digging yourself out of a hole once you put something down on paperwork to the county that doesn't match what's in the records reports that they run. So making sure that you outline the process as much as possible to make things very clear for relatives so that they know what is happening is really important. But I also think there's framing that we can do as advocates to support relatives in these cases. A lot of times, folks who have convictions that are really old, or they've been reduced from felonies to misdemeanors, or they've had, expungements happen and things like that, they stop considering what happened to them to be this criminal history. Like they've resolved it, it's been expunged, all of those things. And so then you come back to your county welfare department, and county welfare doesn't care about any of those things. Every single thing that happened in your past is coming up on these hits. And so there's a reframing. It's like, we understand, we're the advocates, know that, you've gotten your reductions, you've gotten your expungements, you've applied for, anything that, any release that you might have applied for, but the county still needs to know about every little thing, but you'll have the opportunity to explain and you'll have the opportunity to express what happened after. So I think you want to also just make sure that you understand the framing that the relative might have, which is, these things happened in the past, gotten some relief, and it's maybe not to the relative, it's more over than it ever is to the county welfare. We all know in this space that county welfare wants to drag things up forever and ever and ever. And, as humans, we move on. As humans, we move forward. And so sometimes that leads to miscommunication between the relative and the county welfare department because, they got it expunged. It's, it doesn't show up for private job applications. They might have gone through that before and not had it show up. And so, but it's going to show up now because that's, there's different standards for child welfare cases and for dependency.
Thank you, Tyler, so much. Hillary had stated in there, if you let them know that there are exemptions available, they would be more honest. So thank you, Hillary, for that. Kimberly, you have your hand up?
Yes, and then I also wanted to say somebody did say in the chat that, of if the social worker will call you a person of poor judgment if there's a felon in a residence. So again, it's always, I just want to emphasize, it's how you narrate it. So if you are honest with them from the beginning, from the door front, like, hey, they're asking you questions, it's how you narrate it. It's always about your body language and how you communicate with the social worker. So just always be mindful of that. That's all I wanted to add, Bobby.
Oh, thank you, Cam. And Penny, thank you, San Diego SoCal workers, for, making sure the family members are lifted up. And then Lisa, you said, where can I refer clients for assistance in gaining custody? So there is a number of organizations, but the Family Reunification Equity and Empowerment Project, we will have the contact information in the end, and you can refer them over there. And let me see, I'm looking at the questions. Some new ones have popped up. Oh, okay, so Penny said, won't the social worker call you a person of course? Okay, yeah, that's what Kim just said. How, okay, no, we just asked that question. I'm sorry, y'all. Also, we have a question from Meredith. Since you work as parent counsel, can you provide any advice for relatives or a relative's legal advocate on working with parents counsel?
Sure. I would say first that most court-appointed attorneys have very high caseloads. So that would be that they have over 100 clients and they spend most of their time in court waiting for hearings to come up. So I think it's really important to do your own research and come essentially ready to give them an argument. Like it's not that the parents' attorneys don't want relative placement. If your parents' attorney is doing their job, relative placement really increases the odds of reunification. It also allows your client to have more visits. It helps visits move along quicker. So it's really important for a parent to have relative placement. That being said, the parent's attorney is usually looking at a small gap of time before they're called into court on a case. So like you need to be able to present whatever your case is for placement in 10 minutes and be able to give, if you've contacted the worker and haven't heard back, those are things that an attorney, if they're supporting your placement, is going to want to say to the judge. So again, as Bobby said, if you have all of your documentation, if you have your receipts, you got to give them to that lawyer so that they have essentially a quick soundbite to say to the judge, like, I've contacted the social worker, etc. I think I did want to say on the last question, the concern about having a felon in the home, it's not any, like there are many crimes that are exemptable. So keep in mind also that there are many people with criminal convictions who raise their children just fine, and social welfare does not interfere with their relationship. So I think when people are talking about using words like lying or honesty, I think you have to keep in mind that a lot of people have no correlation in their mind between a criminal conviction and their ability to take care of a child, and maybe really shift the way that you're thinking about that. Because if you're approaching families with that kind of judgment, that in my experience, everyone can sense that. And it feels like it's not a safe space, and the stakes are really high if you want your grandkid to be with you, and you just saw your grandkid crying and removed by police, you're going to try anything you can do. So I think just making sure, challenging your own assumptions for why you're using certain language, I think is really important. I think you also need to come prepared to make your case as if you are your own advocate, because you always want to make it easy for the lawyers to pull out facts that they can give the judge. So they, in a perfect world, they would be contacting you and helping you through this. But in a world where they have these enormous caseloads, you need to be providing them with all of the receipts right off the bat, and they can use what they want out of that. But just sort of making a packet to present to those lawyers, I think, is really important. And also just working with your relative, to make sure that you understand what's going on for them. Thank you.
Thank you for the in-depth answer. It was very appreciated. I just wanted to double back about the link that was put in there for the evaluation form. Please fill it out. That would be very helpful to the bosses, as well as there's links in there for SB 354 guide, links to thriving grand families, the SB 354 flyer that explains the core change in plain English. Okay, so here was a question. Are NERFMs included in SB 354 or just relatives? Sabrina?
So SB 354 has a lot of different provisions. The one that we've talked about the most today, about being able to provide an exemption for non-exemptable convictions, that only applies to relatives. There are some other benefits of SB 354, like was mentioned in the beginning about in an emergency placement, the county has to provide the emergency caregiver with some reasonable efforts at material support like cribs and car seats and things like that. That applies to both relatives and NERFMs as well. And certainly, before SB 354, existing rules around emergency placements and compelling interest placements, those apply to relatives and NERFMs as well. But the core change that we are talking about today is just for relatives.
Thank you, Sabrina. The next question says, how does SB 354 play into the Family First Prevention Act?
I can answer that one also, and
Go
feel
ahead,
free.
Sabrina.
Yeah, feel free to the person who asked that to clarify in the chat. But there, as background for everybody in the audience, the Family First Prevention Services Act is a federal law, and it has two major parts. They're just like every law, little smaller parts, but two big major parts. The first is strengthening the requirements for placing a kid in a group home or some sort of group care environment. And the other one is providing more prevention services for kids who are at risk of entering the child welfare system. So SB 354 doesn't directly relate to either of those things. It kind of falls in between because it's not prevention because these relatives are stepping up because a child has already been removed or a petition has already been filed and there's a case in court. So it's not really prevention. And even though I think all of us who worked hard to get SB 354 signed into law hope that more children are connected with their relatives instead of group care, it didn't change any of the Family First Act rules related to group care. So it's kind of its own legal reform that doesn't relate to the federal law.
Oh, thank you, Sabrina, for that. Jarrell said, will this PowerPoint be shared? Rita?
Yes. I'm not sure if you can hear.
Yes. So the PowerPoint will be shared within a week, just to give us some time to get some things together.
I see a question from Jennifer Quinn.
Okay, I'm at the top of the chat,
Oh,
just
okay.
trying to make sure because the questions weren't inside the question and answer. So I just didn't want to miss anybody. Okay. Okay, so now I can go back to the bottom. I caught up with everybody. All right. Oh, really, if you see the question, you can go ahead and ask it.
Okay. Do siblings need to be declared a sibling set or sibling group in order to stay together in care? And if so, who does this? Or how is it determined? Anybody who can answer it.
Really, this is a question for Tyler. Can you repeat it one more time, though?
Can you hear me?
Yes.
All right. Do siblings need to be declared a sibling group or sibling set in order to stay together in care? And if so, how does that happen?
So
I'm not oh, sorry, Bobby.
No,
I'm not aware of any requirement that that anyone needs to declare a sibling set in the same way that there's no requirement to, declare somebody a relative. Obviously, if there's a denial or a decision that's made that doesn't recognize that relative or sibling relationship, then that's something that can be addressed either in court if it's a placement issue or through an appeal if it's an approval issue. But it's not like, with paternity, for example, there may have to be some sort of finding or presumption, presumptions applied. But I'm not aware of, and correct me if I'm wrong, any of my colleagues of any requirement to declare a sibling set.
Okay, and then we have another question from Sia. How about cases in which the children are placed with a relative one already, but another relative two, such as grandma wants placement? The children have more bond with relative two, but there's a criminal history. Should relative two still go through with the RFA process and fight?
Bobby, I'll take that one.
Thank you.
Yes, absolutely. Especially if the family, often we have family who someone acts as an emergency placement, but really grandma is the person who's going to be taking over permanent care. It's very normal to then ask for the agency to go ahead and assess grandma. One other thing I would say that we didn't cover is that you could have RFA approval before a case was opened. It would be a pretty exceptional circumstance in which you might know that there would be a case and want RFA approval. But just keep in mind that RFA approval isn't triggered by whether or not you are immediately seeking a placement. It's something that you can go through. So if the family has a safety plan where you know that grandma can't pass emergency for some reason, or aunt, I'm just using grandma, sorry for grandpas out there who are listening, you're important too. But I think you want to have as the plan that's best for the child. And if that's living with grandma despite her record, then she should be pursuing getting that exemption. And it's always best to have children out of stranger foster care. So I think it's understandable to put forth the relative you have for emergency placement who won't hit CLETS because you're just trying to get the child out of stranger care.
Thank you, Meredith. I have another one. Somebody want to add to it?
Yeah, I just wanted to add that I think this was mentioned during the presentation, but the RFA process is really, really lengthy. So completely second everything that Meredith says. And as many relatives who can go and start the process and get approved, it will be really helpful. Another part of the RFA process, which you didn't have a ton of time to go into today, is they ask you to list anyone who would have significant contacts with the children, who's regularly present in the home. And so often with families, even if, in the case that you're talking about, relative one has placement, if relative two is going to be regularly present in the home, then it would be useful for them to go through this process anyways. And so there's a whole host of reasons that it makes sense to get the process started, even if there's already a placement, because you never know what's going to happen down the line, and you'd rather have that RFA wrapped up in your certificate on file in case anything happens and you do get the opportunity to have the child placed with you.
Thank you so much, Tyler. We got enough time for at least 2 more questions. So if the child is on the emergency placement with a non-extended relative family member, they understand it would take a compelling reason to move placement to a grandparent. Would that be another emergency placement? Will the court possibly require another placement over the slow RFA process? Sabrina?
It would still be a compelling reason placement. Is that, I see Meredith nodding her head. It would be emergency placement and compelling reason placements are both placements prior to approval, but there is more flexibility in deciding, the circumstances in which a compelling reason placement would be appropriate. And that would allow the caregiver to get placement before the RFA placement was, or the RFA approval was completed.
Just to add to what Sabrina is saying, it's a really common fact pattern is to have, especially in situations where there was a police removal, there's a really quick emergency placement with somebody who's present, but that's not the long-term plan for the family. So it is, the agency would not be surprised that you're asking for a compelling reasons placement to move from placement one. And I think, I know there was some talk in the beginning about importance of staying in one placement. There is research that indicates that's different when you're staying in like a kinship circle, right? So it's not traumatic for the child to be hanging out with mom's best friend for a week while grandma goes through compelling reasons. So I think, and the agency also sees it that way.
Awesome. Please fill out the evaluation form during this question and answer session. And I just want to thank you guys for all the questions and answers. The questions that we didn't get to answer, maybe we can get together and answer them for you individually at another time. But we're at the end, and I want to give everybody a chance to that's on the panel to reflect and say their, thank yous and goodbyes. And I will start out with Kimberly Dunn.
Sorry. Thank you everyone for coming. I really, really appreciate it. If you do want to contact me, my email is above. Again, I work for New Way of Life, and I really thank you and appreciate everyone for showing up. This is important to us and important to the parents in the future.
Next, I'll turn it over to Sabrina.
Thanks everyone for joining us, and echo everything that's been said. Please reach out with questions. The Alliance for Children's Rights is a legal services organization. We provide assistance with resource family approval denials and also foster care benefits, denials, terminations, etc. So this is an area where we can provide some technical support, and please do. My inbox is open.
Thank you, Sabrina, for that. Meredith Wallace, would you like to say a few kind words?
I feel like I talked a lot already, Bobby, but thank you everybody so much for coming. My email is there as well. I'm a parent's attorney, and my organization is really, really committed to keeping families together and keeping children in their community. So please reach out if you're having some trouble. Thank you.
Thank you, Meredith. I think we all talked a lot today, but it was very necessary. Tyler?
Thanks, everyone. LAFLA, if you're in LA County and need assistance with RFA or foster care benefits, we can definitely help. And if you're not in LA County, but you're an attorney looking to help someone else, I'm happy to provide technical assistance on the RFA denials. They're a little tricky, but I want you all to take one, help a family, and let's spread this message of all the win that we got with SB 354 and make sure that everyone is able to access the benefits and keep the families together.
Okay, Tyler, you got me hyped up. So I want to give a special thank you to Rita, who has put all this together, made sure that we, were available. We had our facts right, our information together. Rita, you want to say a few words? I know you're not on the slide, but introduce who you are.
Yeah, I just put my contact information in the chat. For myself, I'm a staff attorney, and Ivana Gonzalez is our family unity coordinator. We both worked with the coalition that helped pass SB 354. And please contact either of us. We're very interested in helping implement SB 354, make this victory a reality on the ground. And thank you for attending.
Thank you so much, Rita, for putting this together for the legal advocates, lawyers, and families trying to get their loved ones out of foster care or out of strangers' homes. My name is Bobby Butts. Again, I was your moderator for this session. Reach out to me if you're interested in the free project and any aspect of it that I spoke about. If you have parents trying to navigate, refer them to the free project, and we will get them in the community where we meet twice a week, and we work over social biographies and things just to make sure that they stay in the race to get their loved ones or their children out of a system that doesn't parent but only places. So looking forward to you getting involved with the free project. And in a week, the recording will be available in the written material folder. Thank you, guys.